Alexander Cross, Law Offices of Cross and Associates. If you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received an interesting inquiry on our channel. Let's see here. This has to do with driving under the effects of marijuana. Let's see. What's punishment? What punishment is there to driving under the influence of marijuana? I was arrested this weekend. Well, an interesting thing about driving under the influence of marijuana as opposed to driving under the influence of alcohol is that here in California, you don't actually need a chemical test to be convicted of the offense. If it can be shown that the marijuana was impeding your ability to safely operate a motor vehicle under Vehicle Code Section 23152E, you could be convicted of driving under the influence of marijuana. Now, here's the deal. When it comes to alcohol, the DA doesn't have to show bad driving as long as they could show a blood alcohol level of 0.08 or more. With marijuana, there isn't a certain amount of nanograms somebody could have in their system to where they could say, okay, you've been convicted. At least not in California. I believe in Colorado, I believe in Colorado it's 5 nanograms of marijuana in the blood is sufficient for an automatic marijuana DUI. But California hasn't codified a set amount. So in this situation, the probable cause is going to be very, very, very important. If the probable cause is that you just ran a red light, but you were driving perfectly fine, or you ran a stop sign, but you were driving perfectly fine, that's not going to be real basis for convicting you of driving under the influence of marijuana. Now, if you're swerving like crazy, you're driving super slow, something like that, okay, there. Yeah, that could be used as a bait, not only probable cause, but it also shows the bad driving. Probable cause is just the basis of the stoppage. But in California, you can still get a 6-month license suspension and up to 6 months in the county jail. Now, very few people actually get the 6 months in the county jail, but keep in mind that it is a possibility if you take the case to trial and actually lose. So essentially, the punishment is almost identical to the punishment of a DUI with alcohol. The difference is really on the other side. It's really the proof that the DA has, because generally speaking, when somebody's driving under the influence of alcohol, they just need a 0.08 and we're done. But when it comes to marijuana, there needs to be a lot more research, and driving impediment is that much more difficult to show with marijuana. It's somewhat subjective. But regardless of that, whether it's marijuana, alcohol, or a prescription drug, remember that driving under the influence impedes your ability to safely operate a motor vehicle. And it's extremely dangerous to drive under the influence of drugs, alcohol, marijuana, or whatever. And if you continue to drive under the influence of alcohol, and as a consequence of your driving, if somebody dies, you could be charged with murder. So please be very, very careful with that. Regardless of that, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation in court, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. See you on our next video.